section, page 4, lines 5 through 7. The existing language.
Where's the video? How can I get the video?
Less than 6,500 gallons per day. And shall not require a permit. Been determined it's really just not necessary anymore. Or section 4, lines 17 and 18. When you were talking about the review of a wastewater system that's located in Class A or Class B system under the wastewater pool, there has been directive that
You can hear.
you for consistency with when necessary. Remember that there was language when necessary. We wanted to clarify when required. Under the agency natural resources and implementation. And then there had previously been a reference to section 29A-105 of the Vermont Water Quality Standards. Say specific
The
analysis.
video, he has no video. Sorry.
I think you discussed it. It might just be better to say after.
Here.
No, that's here. So.
And then on page 5, section 5, there was just a confusing phrasing.
It's echoing.
And instead of really reading the content or the substance of the section. Classification on receipt of an administratively and technically complete petition, any administratively complete. So now it's the secretary of the secretary's own petition on receipt of an administratively and technically complete petition shall propose to reclassify any waters where water quality data meets or exceeds the minimum required criteria for a higher class, etc.
Take your chair break. So this doesn't change the actual function of this section. It's just kind of a chronological order.
Well, there was that on petition, that language about receipt of administratively and technically complete petition in the prior draft, but just the way that the phrase was strung together created some confusion. So no, it doesn't change the substance. It just provides clarity about how or really when the secretary will reclassify.
Okay, thank you.
Any other questions? Thank you.
And then on to page 6, section 7, the changes really are on page 7. This is in the non-point source pollution stakeholder group, that group that's going to look at how and whether non-point source pollution from agriculture or silviculture should have the anti-degradation implementation policy applied to it. And so you wanted some additional detail about what that group is going to do. You had some discussions about that. Page 7, lines 8 through 19. The group is going to recommend whether amendments to statute or rule are necessary to improve the regulation of non-point source pollution from ag and timber harvesting, including whether or how to apply the anti-degradation policy to non-point source pollution from ag or timber harvesting, whether and how to regulate runoff from subsurface tile drains in a manner consistent with the water quality standards, and whether or how to improve management of non-point source pollution from timber harvesting, including whether to mandate implementation of the AMPs on all timber harvests and whether to require timber harvesters to notify the state of harvest sites prior to initiation of harvest. And then on page 7, line 21, going on to page 8, line 1, there was no date in the report back, and so a date was added. We'll report back to you for January 15, 2024. And then last, in section 8, the effective dates. Remember the prior draft that you reviewed last week had all sections effective on passage, and there was discussion But how the anti-degradation implementation rule may not be finalized, well, you don't know when it's gonna be finalized, so you made, the substantive sections, contingent upon the effective date of the ANR anti-deg implementation rule, with the findings and the non-pollution report.
Thank
I
you.
do just want to note also, I don't think the bill will go to finance for appropriation, but I don't really know, because sometimes the secretary will send a bill to finance when the universe of permitting actions changes and there's a permit fee. So you might want to talk to the secretary about if it's going to go to finance or not,
Okay,
because he might read this as changing the universe of permitted activity specifically under the on-site wastewater program. And therefore, he might read it as requiring to go to financing. I don't know. I never really know when he's going to make that decision. But it's a possibility.
great. I will,
Good thing we got some folks in there that can talk to the committee about it.
we're talking about the Senate secretary.
No, I know.
Okay, well, so I'll check, and I guess I don't, on a practical level, I don't know whether the fees change if you're moving from septic to indirect discharge, or I'm guessing they're more complicated permit as you go up the gallonage schedule. Ms. Smith, do you want to just give us an update? Thank you, Mr. Grady. Any questions for Mr. Grady?
No, thank you.
Okay, thanks. Ms. Smith, actually, you are one of the authors, one of the drafts in response. Do you want to join the table to walk through ANR's response to the current draft? And then we'll can highlight where you are interested in making further edits.
Sure.
But the particular question was, will the bill as drafted, does it change basically the revenues of the state of Vermont because the permitting paradigm shifts?
No, Mr. Chair, this bill shouldn't change any permitting requirements. It shouldn't change any permitting thresholds, any permitting triggers. It's the indirect discharge permits as required now will continue to be required for the same discharges. The on-site wastewater permits required under chapter 64 would continue to be required for the same activities. This is just looking at whether or not those activities would be allowed and under what circumstances in Class A watersheds and B1 watersheds.
Okay, thank you. So I think you had, yeah, let's walk through what you had flagged for further discussion. Thank you.
Sure. And for the record, this is Hannah Smith with the Agency of Natural Resources. Behind me is Pete LaPlante with the agency and Bethany Sargent as well. They have significantly more technical expertise if that comes up, but I'm happy to walk through the provisions that the agency flagged in the most recent draft. No concerns on page 1 or in any of the findings. Beginning on page 3, the section 2, which deals with the proposed amendments to 1259, the edits included in Mr. O'Grady's last draft look accurate. I think there is a missing word water on the first line after Class A water. And that delineation between waters that were classified as Class A prior to July 1st, 2023 is consistent with what the agency was proposing. We believe those should continue to have the 1,000-gallon prohibition in their watersheds. The agency's position is that beginning on line 13 through 16, this prohibition on disposal of sewage from systems with a capacity of 6,500 gallons or more per day is unnecessary. The agency does not think this prohibition is necessary to protect those waters. Discharges from those systems are required to get individual permit authorization under the indirect discharge rules, and the technical requirements associated with those permits prevent any discharges from reaching surface waters, which is the agency's primary concern. The language in the anti-degradation implementation bill also provides the agency with the backstop necessary to review those permits in greater depth when there's any indication that they might affect the integrity of the surface water. And it's our position that that gives all of those potential A and B1 watersheds the protection that they need.
Okay. All right. And I'm looking at the draft. I don't know if everyone has a copy of what A&R sent to submitted in the exchange yesterday. So they're a little tricky to.
I did not make any changes to the language. So the draft you're looking at, there were no A&R edits to that language.
Okay.
I had added comments. I was trying to avoid
Editing, yeah.
more redlining on the draft.
Yeah.
So in one of the comments, I'd suggested language that simply states, I can read it if that would be helpful.
Sure.
So instead of that line 13 through 16 that's in there now, the agency's draft proposes that for all other waters, so waters that were not classified as A prior to July 1st, 2023, the on-site disposal of wastewater from a system with a capacity of less than 6,500 gallons per day may be permitted within a Class A or Class B water, provided that the system complies with the permitting requirements described in Chapter 64 of this title. Those are the on-site wastewater permitting requirements. The on-site disposal of sewage from a system with a capacity of 6,500 gallons per day or more shall require an individual permit according to the requirements of subsection 1263F of this title. That would be the discharge requirements associated with indirect discharges. It just clarifies that all of those discharges do require a permit and will continue to require a permit. These are the provisions of law under which those permitting requirements are articulated.
Great. Any questions on that? I said any questions on that provision?
I keep getting grabbed by the notion that there were places where water flows into downhill into streams by man-made systems, and the law says they're not direct discharges. And since these sections deal with direct discharges, they don't deal with the water that flows into streams going downhill. Those things are exempt. And going back to where water flows out of a pipe and is characterized in statute as not being a discharge.
So I think Senator McDonald, you're referring to the non-point source runoff. So those also, stormwater runoff also requires permit. It does have to meet the thresholds for the agency's jurisdiction to require a permit, which is new and disturbed impervious surface over half an acre, or certain upgrades to existing impervious. This language is focusing on indirect discharge systems because that's the current prohibition in statute, but it's important for the committee to note that stormwater discharges also require permits, and they would require a permit in any A1 water. And the anti-degradation implementation rule goes into great detail about when a stormwater permit would also be subject to that closer review. A stormwater permit, if there was any indication that the additional stormwater runoff would affect the integrity of the surface water. It would also, under the anti-deg rule, be subject to further review.
There is a section later on, the last section, the study section addresses the non-point, issue that we.
Non-point, when we use the word non-point, we're using a legal term.
Right.
We're not discussing physics and water anymore. We're using a legal term that appears to contradict what our eyes view and what we watch happening. So that's the
Sure, and so I hear that question, but I'm thinking, so let me check with people more expert than me, that those are really distinct issues and that we're talking about the whole, I always think of these on-site septic and indirect discharge permits as keeping water in the ground. It's a discharge below the surface. So the kind of thing you're talking about is another situation altogether.
is different than, yes, the
Yeah.
two are different.
Right.
The place that receives going downhill isn't smart enough to detect the difference that we're able to detect.
The anti-deg rule that the agency implements does point to the permitting requirements that are associated with the different types of discharges that are regulated. So the focus here again is on the indirect discharges, and the permitting regimes that manage those discharges are they're explained in pretty extensive technical rules. Management of stormwater, so the non-point source runoff that you're referring to, is managed in a different way under the stormwater management manual. Both of those manuals, though, are updated on a regular basis in order to keep pace with advancements in treatment of any kind of discharge.
So when I hear that, and ask another beginner question, indirect discharge, it sounds like something you might observe, but my understanding is that all these kinds of systems are subsurface, and you don't end up, there is no observable discharge. You're not seeing something from one of these systems flowing into water state. I don't know.
That's correct. Right.
I don't know to what degree below the surface they can travel, but I get that part of the analysis in here too.
Right, that would be part of the technical review conducted by either the agency or an engineer who's designing one of these systems to look at the soil, the slope, the rate of infiltration, whether anything needs to be captured and how, yeah.
I'll stop there. The witness says that there's a case in which the water is managed in a different way. And I contend that according to statute, they're exempt from being managed in any way. They're not managed in a different way. They are exempt from being managed.
So I'm a little hard for me to sort this out. I think the situation you're talking about, though, for instance, that the kinds of situations listed in the report at the end are a distinct category of activity separate from these septic systems that we're writing statute on in this part of the bill. So maybe, I don't know if we can look at the report part later, and that will address your concern.
Yeah. And then we'll look and see who the state members are.
Another clarifying point, 1263 refers to discharges. Discharges are defined as either direct or indirect. So in terms of the agency's jurisdiction, we manage direct discharges, indirect discharges, and stormwater runoff, which is a category of non-point source pollution.
Thank you. I think some of the language is not all that intuitive when you hear it the first.
I won't disagree with you there.
Okay. Thank you very much. Okay, so are there any more edits you'd like to point out for page 3?
The revisions to 1263, it's the agency was a little bit confused by the addition of this May 1st, 2023 date. So when this language was adopted, it was intended at the time. The reason the 1991 date is in there is this language was adopted in 1986 at the same time that the 1,000-gallon prohibition was adopted. And it gave existing indirect discharges 5 years to come into compliance with the agency's indirect discharge rules and to get the necessary permit. So it is sort of written in a way, it's at this point, you know, that 1991 date is no longer relevant, but the language in this statutory section doesn't conflict with anything else that the agency does, except for that last line, which is on page 4, lines 5 through 7. And it's struck through in the committee's draft. Existing indirect discharges from on-site disposal systems less than 6,500 gallons per day shall not require a permit. That is incorrect. Those systems do require a permit, again, under the on-site wastewater program. So that language is really no longer necessary, doesn't control at this point, yeah.
Are you, Mr. O'Grady had shared the notion that on the beginning of F above, that we retain the original language and just strike the phrase no later than July 1, 1991. Is that?
Yeah, from the agency's
Consistent.
perspective, that makes sense. I think the other important thing to know is that the current draft on page 3, line 18, the first sentence of that section, it's currently written so that it states indirect discharges to class B2 waters from on-site disposal shall comply with and be subject to the provisions of this chapter. And it really should say, as it does in the current language, that it indirect discharges to waters of the state. This, when it was adopted, it meant any indirect discharge to any water must comply with the permitting requirements. I believe that's still the case, and I'm not sure why this distinction would be made.
Can you read the sentence again where you would propose a rewrite?
It's the first sentence of section F, so page 3, line 18 through, the line 1 on the next
Mine
page.
is, sorry,
Page, bottom of page 3, line 18.
my numbers aren't lining up with your numbers.
Oh.
So if you can read like the section letter and then the language that you're proposing to change.
Yeah, this is section 3.
Yeah.
Revisions to 1263F. The agency would suggest that we leave the current language intact that says existing indirect discharges to waters of the state from on-site disposal of sewage shall comply with and be subject to the provisions of this chapter and shall obtain the required permit.
Sorry, can you read that one more time? My markup's getting a little confusing here.
Sure, I am suggesting that we leave the language as it's written in statute. So it would read, existing indirect discharges to waters of the state from on-site disposal of sewage shall comply with and be subject to the provisions of this chapter.
Thank you. Sarah?
Thank you. This may be small, but I don't know why we wouldn't change the first line to indirect discharges, which is to say, that it applies to both existing and any future.
We could do that. I think that, yes, that would not, again, conflict with our current permitting program.
Right, yeah.
Mr. Chair,
Senator McDonald.
Existing and future. And what isn't discharged. We have changed our policy in the state of Vermont on how we deal with storms. And the hard workers and the heroes in this are the people that build and maintain our roads. And for years, we told them to get that water downhill and away from the road as fast as possible to preserve the road. And we have changed the policy to say, slow that water down. Don't let it rush downhill as fast as it does. Stop. And that is like taking an entire army and turning around and have it march in the opposite direction. And that's a big task. When it comes to the one thing I always bring up, which is tile drains, when people buy future agricultural land, the first thing they do is get on the phone and they call up a contractor to come in and dig through the damp, marshy, or wet soils and put a pipe in there to collect that water coming from there and get it downhill faster. We have suggested that when they do that, they make a record of what they've done, so we know where it's happening. And that there be some measure or accounting for how much water is being shipped downhill faster. And now we're gonna have a group of stakeholders who regularly dig into the land and put the pipes in there to get water downhill faster, that are gonna make a recommendation to us. Why? Does anybody want to bet on what you're gonna recommend?
I believe you're referring to that section at the end of this bill. I'm not gonna make any bets on that front. I don't know what they would recommend.
I don't think anybody in the room would bet against what they recommend.
Do you want to just point back to this section of the statute, only dealing with the indirect discharge permitting program? The stakeholder group that you're referring to, that's outlined in the end of the bill, right, is looking at, the way that it's written, it's looking at different categories of non-point source pollution the agency currently does not have jurisdiction over.
So for the section we are in, we just finished section 3, I think.
Yes.
And can you, Senator Watson?
Sorry, did you say the agency A&R does not have jurisdiction over tile drains?
Currently, they are looked at as infiltration systems, and there is, the Agency of Ag has jurisdiction over agricultural non-point source pollution.
So it's a different agency.
Yes.
Thank you.
There's debate over the nature of those discharges, and
Okay.
yeah.
No, that's fair. Thank you. I appreciate that.
So I appreciate we're touching on a big topic, but I'd like to continue walking through what we have. I mean, the question, that's fine, but let's keep going through the edits, and then we can have a bigger discussion on the last section of the bill when we get there. Just want to make sure we have the other stuff buttoned down that we possibly. Okay.
Sure. Beyond that section 3, the agency does not have any requested edits. We did, let me take a step back. On page 5, in the revision to section 1252, I think the edits make sense. They read very clearly. I would suggest, this is the revisions to 1252I. The highlighted language says on the secretary's own petition or on receipt of an administratively or technically complete petition, the agency would suggest on the secretary's own motion. Semantics, but we don't, the petition process is a
Yeah.
public process.
Thank you. There's also a proposed date change on the next page.
Yes,
Can you-
section 6, this is the report back to the legislature on the effectiveness of this statutory change related to reclassification. And we would request that the date just be pushed back 1 year, assuming that we, if this is adopted, the additional year would actually give us some data to work from to report back to the legislature in terms of reclassification.
Is there any value in, I hear what you're saying, it's like you're not really running the program yet, thank you. Then there's not much to say, right? You're not operating yet under the new paradigm. Is there any value though, next January in saying what the status of the sort of a snapshot of the system prior to full implementation is? That's what I was thinking is one reason. Because we would see, for instance, the list of all the eligible waters at that moment in time, even though that implementation hadn't happened yet. And it would mean that the next, in 25, we'd be able to compare 24 and 25 and say, oh, so these have all advanced from last year's list to reclassify that kind of thing.
This would, yeah, I think that if the committee is interested in an initial report providing a status update, then the date is not critical. We just wanted to give ourselves that buffer with the understanding that there, depending on the rulemaking process, there might not be a lot of reclassification happening between now and January.
Sure. Well, that would make a lot of sense. I mean, our expectations for the report as a baseline sort of starting line snapshot compared to subsequent years, but I think starting line snapshot might be helpful. Okay, thanks. So I propose that we stick with 24.
That's fine.
Thanks. Anything else you'd like to flag?
No other revisions from the agency.
Okay. Any questions for Ms. Right. With that, so for the advocates, I don't know who wants to speak on behalf of Basin needs to become sort of a de facto point person. Sometimes it's Mr. Groveman, and sometimes Mr. Carpenter. So you want to choose amongst yourselves for walking us through your proposals.
And I don't think we should, thank you, Chair. Being a whole, and I don't need to sit down. I mean, we don't, basically, I think we don't disagree with any of the changes suggested, except, yeah, I think the issue is the 6,500 limit or, some limit on, just like I said on the Zoom on Friday.
Yeah.
There's two aspects to all of this. One is the wastewater systems and their review. And I think that the bill does a good job of, zeroing in on that, especially the anti-degradation rule. But the 1,000-gallon limit also did address, some limitation on density, intensity of development. And that's gone. And the 6,500 was an attempt to bring some aspect of that in and recognize that that is also an issue, in terms of the potential degradation of these waters. And I think you said it really well, Chair Brand, on Friday, that it's an issue, how do you deal with land use controls? And I don't disagree with you. In a more perfect world, we'd be able to adopt land use controls, but they don't exist now. And you know well how difficult it is to expand the, certainly statewide, land use controls. And so as this change is being made, that's where the 6,500 comes from. And we just don't agree. I think the committee is just gonna have to make that policy decision.
Okay.
So I don't really need to go through this stuff. We don't object to changing any of the specific language that, Council Smith. Thank you.
Okay, thank you. So we'll hear a little more testimony. I know that we have both Mr. Nelson and Mr. Coleman with us. So any questions for Mr. Grover? Seeing none. Good morning, Mr. Nelson. And let me just check in with Mr. Coleman, who's in the room. Do you both wish to speak, or you want to go one after the other? I'm just trying to figure out who would like to contribute to the conversation. Good morning.
I think this is Warren Coleman. We both want to contribute. I'll see what Jeff covers and if cover anything that he doesn't touch on.
Okay. So thank you. Good morning, Mr. Nelson. Good to see you again. What would you like us to think about on the current draft?
Good morning, and again, for the record, Jeff Nelson with VHB, and I've been working with ski areas and been involved in the stakeholder group on anti-degradation. So I think that it's really important to keep in mind that there are sort of three different things happening here. One is the anti-degradation implementation rule that we've been working on with the agency. Second is that the opportunity that we see for reclassifying waters to higher classifications. And thirdly is this statutory prohibition that creates, as the agency has gone over several times, the perceived or real impediment to reclassification. And these three things are really very strongly linked. And we feel that all of them are very important. The regulated community has certainly accepted a number of compromises in getting to where we've gotten in the implementation rule. There are certain things that are going to be more challenging to do, certain things that are going to be more predictable in terms of when you need what kinds of permits for certain activities. But we feel on balance what is currently being considered as far as the implementation rule for anti-degradation makes sense, and where waters are eligible to be reclassified based on actual data, they should be, and creating a public process where landowners don't feel that they are going to be told that there are certain arbitrary prohibitions is something that I think is important to allow these other things to happen successfully. The agency has also spoken to the fact that the current permitting standards for wastewater systems, whether they're the smaller systems that are regulated under the on-site rule or larger systems that are regulated under the indirect rule, are very stringent. And, having worked on many of those, our firm certainly is well experienced in understanding what the technical and engineering criteria are for both of those kinds of systems. And the reality is that there are many sites that simply can't accommodate those kinds of disposal systems because of slopes or soils or distance to waters and so forth. So, I know John a few minutes ago just referred to a more perfect or a more ideal world. I sort of feel like we have that more ideal world because the technical criteria for wastewater systems is incredibly protective, and that's why being willing to live with criteria that speak to no physical, chemical, or biological measurable change, which are obviously incredibly stringent, is something that I think should give you confidence that eliminating an arbitrary gallonage prohibition doesn't create undue risk to the waters. So anyway, I'll leave it at that. I guess the long and the short of it is that we support the changes to the draft bill that the agency went over a few minutes ago. We think those changes set the stage for a successful outcome in all three aspects of what I spoke to: the anti-deg rule, reclassification and then not having an arbitrary number that's going to really make it difficult for the agency to do these reclassifications that make sense. So I'll leave it there. Thank you.
Great. So since you designed systems and participate in the process, I think one of the concerns that's come up is, do we have a stringent enough process? And the new one, I'm hearing from everyone so far that they believe the permitting process in and of itself is protective. The other question I heard was around impacts over time. So can you say something about the cumulative impact assessment? And I think, talking with someone this morning, they said, well, what if each permit is well issued and designed, but we're not noticing the cumulative impact because multiple permits have been issued, in the same watershed?
Sure. So, that gets looked at in a couple of different ways. First of all, at a watershed level, the agency has an ambient biomonitoring network which looks at the quality of waters over time, and that basically is tracking where there are watersheds that are being potentially impacted by cumulative impacts. And then secondly, when, and particularly under the new anti-DEG rule, when an applicant comes in for a project that, falls into the category of having to go through the Tier 2 anti-DEG review, that is expressly called for in the rule. And so basically, and having done those kind of cumulative impact analyses for larger projects, it's basically an inventory, whether you're looking at a cumulative impact for wastewater or for stormwater or for some other kind of discharge, basically inventorying what those existing discharges are in the watershed, what kind of monitoring is being done, what kind of impacts are being observed, and then whether or not the new discharge would, based on modeling and assessment, put a water in a situation where it would not meet the permitting threshold. So it's not something that's done often, but for larger projects where you have a number of existing discharges in the circumstance that you just described, that kind of analysis has been done and is something that is more expressly called out now in the proposed anti-DEG implementation rule.
Thank you. Any committee questions for Mr. Nelson? All right, thank you.
Thanks.
Ms. Cole, would you like to join us at the table? Welcome back to the natural 2023 edition.
Do all over again. Good morning. Just want to focus quickly on two things. One is what Jeff was just touching on, which was I'm sorry, this is Warren Coleman with NMR. As I said last time, I testified as part of the stakeholder process and have been involved with this rule or its prior iteration, this policy for 15 or 20 years when I was at ANR. So Jeff and I were trying to represent the perspective of the regulated community. There's a number of entities that I represent and work with that have indirect discharge permits. So I'm just going to speak to the
Can I
limit.
just ask,
Yeah.
Mr. Chair, who are those folks?
Well, like for example, Cabot, Agrimar,
Okay.
a number of the ski areas. So there's, and I'll give you some examples.
Okay.
So just to put some
Just, yeah.
context. So the issue that we talked about last time was, and Jeff hit on this, was we're trying to promote reclassification, and the 1,000-gallon limit has been an impediment to doing that. What we're doing here by putting a 6,500-gallon new limit and prohibition of anything over that, unless you're sort of fixing the system, is creating the exact same sort of impediment. The reason I say that is when you say that in a B1 water, you're not going to be allowed to have an indirect discharge permit above 6,500 gallons. The committee hasn't even explored the types of indirect discharge permits that are out there right now. So I wanted to give you a flavor for what we're talking about potentially prohibiting or not renewing those permits. These are, there's a whole host of different ones. We have cheese makers like Cabot, Grafton, Vermont Butter, and Plymouth, who all have indirect discharge permits. What they're doing is they're actually taking their wash water from their cheese making process it gets land applied to hay fields, basically as for irrigation, and because it's got organics in it. So it's basically a way to help those, that grass grow. And these are in rural areas, so they're not discharging into a wastewater treatment facility. This is a way they get rid of that processed water. You've got ski areas, some of which have the disposal, basically, frankly, of septic is land applied. It's basically sprayed. You have other resorts like Basin Harbor Club, Quechee Club. You have a number of breweries. Think about the breweries in some of the rural areas. I know we all visit them and can probably think of some of them. They also do the same thing. They basically think about the amount of water that they use to wash their equipment. It's food grade stuff, and then it ultimately gets land applied. These are all indirect discharge permits. And when you say an indirect discharge permit in B1 water is going to be prohibited, we haven't even talked about what the implications of that may be. And these are, speaking from the permits I've worked on, they're very heavily regulated. Surface water and groundwater are very heavily monitored. And quite frankly, I would expect there would be some candidate waters to be reclassified from B2 to B1 in these watersheds where these indirect discharge permits are currently in effect, which suggests that they're compatible uses, right? That these activities are going on, and the aquatic biota are saying, we're better than B2, we could be B1. They should be reclassified. So you've got evidence that, and there's literally a couple hundred permits of this sort of commercial, industrial, lodging type of indirect discharge permits. Again, whether they're for food processing and beer, or whether they're for resorts, for ski areas, or whatever that are out there. So you're going to create the same situation that we're trying to get away with from the 1,000 gallon situation. You're going to put a new threshold in there, and when the agency goes to reclassify something as B1, we're going to say, well, what about these 3 or 4 different indirect discharge permits? We've got this brewery that's going to apply no wash water. You've got Bracken Cheese or whoever it may be. So to echo what I think you've heard, I think you got to have some faith in the indirect discharge program permitting process. If the bugs in the fish say it's a B1, then we should be able to reclassify it and not have an arbitrary permit prohibition where we've got permits that are already in place and that we know what are working. So that's I just wanted to sort of illustrate, because I don't think we've talked about the universe of the types of activities that are also will be prohibited under the language. I'll stop there and see if you have questions.
Thank you, Chair Bright.
Sure.
I really appreciate you coming at it from the business perspective, because that is the group that I'm most concerned about, using some of the changes to create some concerning changes around our waterways. So I respect that you work for some large corporations that are interested in expanding in and around some of our potentially reclassified waters.
Yeah.
So I guess what I'm confused about, though, is what are they hoping to build that's over the 6,500 limit?
I'm talking about, I'm not even talking, I'm just talking about the status quo. These are all existing permits and operations for the cheesemakers, for the breweries. If nothing expanded, I'm just talking about the status quo right now. If every 5 years they have to go and renew their permit, which they do, just like most A&R permits. So let's say the gallonage, everything stays exactly the same. The language here just tees up that same issue that we're trying to get away from on the 1,000 gallon, which is the language here basically says an indirect discharge permit would be prohibited. So does that mean I couldn't renew that permit, or does it mean that it's no longer? So that's the issue. I'm not even thinking about expansion. And in a lot of cases, sorry to interrupt, in a lot of cases, some of the companies I'm working with are actually trying to find ways to reduce the amount that they're land applying by looking at biodigesters and other technologies because quite frankly, it's expensive to truck stuff around and land apply. So the more they can eliminate that cost, that expense, and find more productive uses for it through a biodigester, for example, are things that they're interested in doing.
I appreciate you explaining that to me.
Okay.
One of my concerns is that as I'm hearing you testify, you're saying that these permits already exist and it seems like it's working well. Maybe a bit of annoyance with continued regulation. But I don't understand how this bill would limit those permits moving forward in a way that would be taking away from the business operations.
It says, it says on page 3, and I did check with A&R last night to make sure my reading was correct, and they said it was correct. This is that language on the bottom of page 3, lines 13 to 18. It says the on-site disposal of sewage from the system with a capacity of 2,500 gallons or more per day in Class A or Class B1 water is prohibited except where necessary to address a failing system or the upgrade of the existing system
Yeah.
to improve water quality.
So that seems like that seems like you have that. You're explaining that that's something that some of the corporations would like to do. But my question here is, are there these large systems that would be unable to continue to be permitted?
That's the question I'm asking. This is saying
And
there's a prohibition unless you are addressing a failing system. So
Yeah.
if you've got a ski area that has an indirect discharge permit currently for septage and it's above 6,500 gallons, I don't see how in a water gets reclassified as B1 as it should, if the biota, the data suggests it should. I don't see how you get a permit if the language here basically said there's a prohibition for the discharge above 6,500 gallons. Let's assume the discharge is above 6,500 gallons.
Yeah, I'm just wondering so the examples you're giving are large ski areas.
They could be ski areas, they could be, and to be fair, the breweries and the cheesemakers are not considered septage. They're not septage.
That's what I'm trying to think.
But there are other disposal systems that are septage that are above 6,500 gallons. I just got the list this morning from DEC, so we'd have to call through it, but the list is several hundred long that includes, and I haven't sorted through to see. It's probably fair to assume that the ones that are for lodging, like Basin Harbor Club, I don't know what their gallonage is, but those are most likely for septage, and the food processors, the cheese, the breweries, the ice cream are not, are non-sewage. So
the very niche kind of group that we're concerned about that you're testifying under are large lodging-based locations that would like to continue operating in the way that they're discharging right now.
They have existing permits, and this just calls into question whether those permits can be renewed, and it just tees up the issue that if the watershed is right for reclassifying to B1, it's the same issue that we had before, right?
So this is where I'm like, this is the crux of the issue for me, is I'm not very persuaded by the idea that we need to be expanding this in any way for large corporations.
I don't think there's an expansion.
Let me just finish the question, because I want to understand, because I do want to vote yes on this bill.
Yeah, so
and this is kind of the, so this is kind of the crux of the issue that I'm trying to understand. Why would we want to risk these waterways possibly, because they should be reclassified? Why is it not something that corporations or your clients understand as a value to reclassify and then maybe not do the type of discharge that they're doing? Like, why is that not a process? Why do we have to change the regulations to be more accommodating?
I don't think we're trying to change the regulation. What you're trying to do here is you're trying to change the regulation with this language by saying
that's what
the current process would no longer be valid.
And the way that the waters exist now, they should be reclassified as a permit.
And the current permitting process is showing that it's consistent with being reclassified. So if one of the ski areas has a indirect discharge permit, and it's had it for 25 years, and that water body, that's the closest water body, Jones Brook in, I don't know, pick a town, meets the B1 criteria, it should be reclassified.
It should be.
So because it's the same issue, people are going to be reluctant to do the reclassification.
Yes. And
so that's, I think you're recreating the issue you're trying to get away from with the 1,000 gallon by putting in 6,500 gallon. That's the simplest way to put it. Instead of talking about small residential, now we're talking about a class of indirect discharge permits. That's really what it boils down to. It has nothing to do with expansion. It's just there's an existing set of permits out there, and this is basically saying those are no longer, the way I'm reading this, those are no longer going to be allowed.
Thank you. Thank you. That was really helpful.
Thanks. Senator McDonald, Senator Watson.
Just Googling the trying to find a cartoon from Newcomb about where on the ski areas where the apple would meet the and it was a big issue in the ski areas. They worked hard to see whether they would take treated water that was rather than release it into the streams to make snow out of it. There was a proposal to use that water to flush all the toilets in the resort and to use it over again to try and deal with it. Those discharges have been recognized. The data is collected, and when we know that water runs downhill, it's permitted. Several of those activities are modified and been permitted. The cheese way used to be, still is. Wash water is sprayed on fields. Sometimes it's drilled into the fields like manure, which is sprayed on the fields, and those are regulated. What I keep griping about is stuff that is declared not to be a discharge, and since it's not a discharge, there's no data, and there's no this, there's no that, and there's no attempt to quantify or regulate. So, but this is 1985.
Keeps coming back.
Well, but it has been addressed. People may be critical of it, but the record and the data is there, and the regulation is pretty clear, and the practice is it's not.
Yeah.
It's regulated.
Yeah, I just think what I'm struggling with is why we have to change the regulation versus asking large corporations to not. Like that's where I'm struggling. Like, what is it? I haven't heard a very robust economic argument that is.
What I'm saying is we're not asking you to change the regulations. We're asking you to keep the current regulations in place that govern how the systems are designed and permitted. The draft language in the bill changes.
Yes. But that's to make sure that people feel more comfortable with reclassification to get the benefits that you're describing. So I buy the argument around reclassification. What I don't buy is the other half of that, which is that we need to change something to get the reclassification. What I'm hearing is there's pushback from communities that they don't want to move forward with reclassification because of this limit. So my belief is that fair enough, I respect that. Especially for residential homes or a school, that all clicks for me. And we had the woman from Caspian who reached out to us, and they have some failing systems. That all makes a lot of sense. What doesn't make sense is why, and I respect you saying we should have faith in the permitting process. I totally do. I want to. I don't necessarily right now. And that's why I still feel comfortable, would feel more comfortable with the $6,500. The cap on the gallonage, but I respect where the chair is going with this bill, and I will be again voting in favor of it with or without. I just think it's an important reflection that maybe the corporate community could look at on why those locations are so ideal that we have to possibly risk going over that amount. Like at some point, maybe
You and I can talk more offline. A lot of these permits are well above that currently, so but they're not asking for it. They're asking for a change. This language just basically says, so what happens to the status of those existing permits if you put a prohibition in place? That's I'm happy to talk more with you offline.
Sure.
thank you.
So one thing, I thank you both.
Yeah, no, it's
Helpful to
very
hear the
good.
back and forth. The phrase there, the on-site disposal of sewage, that was catching me at first because I was thinking wash water is now being sewage.
I stand corrected. That is there are non-sewage. The food, most of the food, brewery, ice cream is not, as far as I can recall, is not classified as sewage or septic. But there definitely are a huge number of IDPs that are more associated with lodging, housing, that sort of thing, which I think would fall into that other category.
And
Peter Han, it's a nod to.
right, so if you could share that sewage definition with us, which is maybe a little broader than what an average person would think.
This is a definition of sewage under the indirect. It's waste containing human, fecal, coliform, and other potential
pathogenic organisms from sanitary waste and used water in any building, including but not limited to carriage water, shower and wash water, but does not include stormwater.
What is carriage water?
Is it from Heritage?
Oh,
Well, anyway,
Unwanted stuff.
Transport waste is what I'm thinking.
That sounds very logical.
but so the key thing was that it included like wash water. So it sweeps in the breweries and stuff that we might not think of as having a sewage.
Water is a conveyance.
Senator Watson.
Thank you. I hope this is a short question. I think it might actually be for the ANR folks. But before I get there, thank you for this testimony. It's very helpful. It's also helpful to think about how the 6,500 limit applies to sewage, but not necessarily other forms of, spreading indirect discharge water. My question for the ANR folks is really about the chemistry. So in the indirect discharge permits, is the chemistry of what is in that water considered? I guess what made me think about it was thinking about the wash water from agricultural industries seems, it's organic, right? And that feels okay. But, I'm thinking about dry cleaners, asphalt factories, just other kinds of industrial processes where you might have more exotic chemicals. Is that built in, or is it just volume of water?
I would probably have to get back to you to
Okay.
give you a detailed answer because I would have to look, because again, the indirect discharge rules are extensive and they talk about different types of facilities. And I'm not sure the extent, I don't know if you have, either you or that may have a better answer about the extent to which different industrial processes are considered differently under those rules.
I think it would be.
Okay, that's great. And I realize it's not.
Things like that wouldn't be something we would seek to infiltrate.
Right, there are other
Okay.
permitting programs that
Okay.
authorize capture.
Okay.
of Certain, yeah,
Types of industries.
yes.
Okay, that's helpful to know. Thank you. And yeah, I don't really want to try to address anything more outside the scope of what's in this bill, but it's just good to know that that's covered somewhere. Great, thank you.
Any other things you can get to or any other?
Just quickly on the stakeholder group, I think Mr. O'Grady sort of outlined part of the issue last week. I think the stakeholder group would be fine if it basically was an evaluation of the RAPs and the AMTs to see it, are they protective enough for water quality and Class A and B1 waters. I think when you start trying to tie it to anti-DEG, the wheels start to come off a bit. There's really not a federal nexus there. Anti-DEG is supposed to be for new and increased discharges under ANR's jurisdiction. I think and quite frankly, I think it's gonna, and I see the Lord DePietros here from AAFM, so I'm sure she'll probably want to weigh in on this, but I think it's a real stretch to start talking about how you modify the anti-DEG rule to deal with the RAPs and the AMTs. I think it's a different thing and a valid thing to ask about looking at those and whether they are protective of the water of Class A and Class B1 waters and whether there's revisions to be made to those. But I think it's a stretch to try and tie it to anti-DEG.
Okay. That there is a sub A is about how to apply Vermont anti-degradation policy and non-point source pollution. So I take your point there. It may or may not be applicable or a good fit. There are other aspects of that report that are like number one, analyze whether the RAPs and AMPs are sufficient to protect Class A and B1 water.
I think that's really what the crux of what, I think if you said you create the stakeholder group to review, investigate whether, and you just go straight to that B1, that hits the issue. I think the rest of the day about recommendations regarding the anti-dig policy. I think that's where I think it runs afoul of, I think, every understanding that I have of anti-dig, the Clean Water Act and ANR's jurisdiction. And I think it confuses things, but that's.
The report could say that, you know. I mean, I think that's part of why everything was on the table in the study. And there were questions that were surfacing repeatedly, so we thought it was worth calling some of these things out explicitly so that it was clear that they would sort of get their day, they would get some level of analysis by the group. Okay. So thank you.
Thank you for giving me some time this morning. I appreciate it.
Thank you.
Ms. DePietro, you joined the committee. I don't know if you came to listen or you would like to participate in the conversation, because we're looking to wrap up the bill and vote. And actually, glad that you're here because we're talking, the RFPs come up again as part of the study. So I don't know if you want to offer any comment to the committee or no.
Sure, do you want me to?
Yeah, please. Join us at the table, introduce yourself, and we'll take advantage of your appearance.
All right, great. Good morning, everyone. I'm Laura DePietro, and I run the Water Quality Division at the Agency of Agriculture. So just a couple things, just want to make sure you have the legal framework, because there's been a lot of questions about, is this necessary? Do we already have the power and authority? And I would say that you already have all the power and authority you need. You don't need a study. So to lay that out, to explain it, first off, in the RAPs, there's already a setup where the Agency of Agriculture has authority. If they're insufficient, we can require more. So we have legal authority to go and enforce, to say it's not working. Second, as the advocates know in this room, there is under our BMPs, which means like even more comprehensive practices than the RAPs. And I know I'm using acronyms, sorry, but there's a different set of rules and it says you have to do more. Those, for any particular watershed where there's an issue or where a neighbor has an issue, someone can petition us and say, we think this needs to be improved and you need to put these regulations in place to require these practices in this area because it's not meeting the water quality goals of the state. So there are two avenues already in the setup that is in place that requires that, and they have been used, both of them. So there's that, but then also I just want to lay out that, you know, the study that you've set up there to look at, essentially it's, what was it? It was like 18 farms out of 1,800 farms or some number like that. Like it's very, you're looking at this tiny little slice with the stakeholder process. And the majority of it, nearly 80%, are farms like yours, Senator McDonald. They're not farms that you're thinking about when you think about, and you know, big tile and layout and, you know, large cropland. You're talking about hillside farms that are very small, family, often hobby operations. So when we regulate farms, we have categories. We have you're below our threshold for small farm, and we have certified small farm. You have to report to us and work with us, medium and large. The majority of the farms you're talking about are in the small farm group. So before certification, yeah. So you're talking about really tiny operations on hills, not like you're just missing, I think, what the conversation is about, because these watersheds, these high pristine quality watersheds are up in these higher elevations typically. So with that said, time, energy, effort, you know, my job is to regulate farms and to make sure that we're doing it. I've got a job to do. Appreciate not spending time on a study that we already have two ways that we can regulate it, and it's not the population that I think that you're trying to target.
When you say, thank you, and when you say 18 farms, what criterion in here that's being examined limits us to 18 farms?
I'm sorry, say that again?
Well, you're saying we're addressing 18 farms of 1,800 or whatever, and I'm wondering why you say that. Like, what piece of the requested, you know, the things to be considered, what limits it from like all farms down to 18?
The intersect of the watershed. So what I had our staff look at is the current watersheds that are classified, and then the reclass potential group. And so within that group, there's just very, very small, and I apologize, I think it's 81. I mixed my numbers, but 81 and 1,800, still very small population scattered throughout the state. And it's just, again, you look at it and it's the majority of those just smaller hillside farms.
Okay, and so, make sure I'm following, so if we were to reclassify, are you saying based on the current list of roughly 120 waters that are, the data indicates they're eligible for reclassification to a higher level, then it's that list that intersects with 18 farms. They are butters to those water, they're in those watersheds or whatever.
Yeah, they're in
And
the
the rest are not in a high quality waters.
Correct.
Wash. Okay. Have you, okay, so that's helpful to know, 81. And how about, have you done, it's a bit speculative. I don't know if you look forward to, if over time, the number grows significantly larger than 120, how large that pool of 81 becomes.
Again, you're talking hobby farms, essentially, right? You're talking folks that are doing things just because they have a parcel of land that is relatively big enough. And, it was a farm years ago and now is, we're talking horse farms, we're talking beef, like 4 or 5 beef. Like, I'm not talking, the 800 plus cow that is in the flatter lands. So I don't see that, if you're going to have a resurgence, it's going to be a resurgence of localized small agriculture in these areas. Again, not the ones that for us tend to have major issues for water quality. And again, there are a lot of grass and those kinds of things. Like, it's less than it's around 3% of the total cropland in the state, and that's hay and corn. So it's like very little bits of likely, and I don't have good data to know exactly what's in hay or what's in corn, but I feel confident saying it's probably majority hay, just because of the slope.
Thank you. Yeah, I think, so another way to look at that same issue is that if the intersection of these two sets of concerns is narrow, it would also not be that time consuming to say we are actually excluding all but 81 farms. And even in those cases, I think it's been a persistent question. Water quality and the regulation by 2 different agencies has been an ongoing point of discussion / controversy, etc. So I think that's the underlying question is, are we regulating to the same standard under the 2 paradigms? And honestly, it seems like it's a fair question to ask. I don't know what the answer is. I'm not betting on what the outcome is. But rather than have it fester as an ongoing conversation, it seems useful to have it as an explicit conversation.
I would disagree that those 2 things are related. So if you're going to talk about A&R and regulating farms, they have the federal requirements to do that. So that's the CAFO requirements. Many, many states in this country have no non-point source agricultural requirements. Vermont does, and we have some of the most robust, I think, in this country. And so whether you like it or not, they are the most robust. And the reality is that A&R is not required to do that, even if they did have jurisdiction. So the non-point source aspect of it. So the reality of, and 2, don't forget, in 2015 and in 2018, we revised the required ag practices, which are the non-point source rules for farms. And we overhauled them significantly to deal with Lake Champlain. And we then applied them to all of the state, right? So not only, most of these watersheds are in the rest of the state. But again, do you really want me to take the regulations, revise them, and focus on farms like your farm, Senator McDonald, and put additional regulations on them to be able to meet requirements that, if I were to look at them now, I would say that they're I think, sufficient, because you've already got these waters in this space where they're already being reclassified, and these farms have already been here for 100+ years, many of these farms, right? So I just don't think there's a new issue or anything that needs to be solved in this space, other than the current regulations, making sure we implement them and doing the job that we've been doing, because today the waters are there and in that state, and that's been the paradigm.
Sarah Watson?
Yeah, thank you. Thank you. This is helpful for just knowing situation. And so I just want to make sure that I'm hearing you correctly. So the 81 farms that we're talking about, under the regulations that you're checking for, I mean, are you finding that I know you have the authority to check on water quality, but I mean, are you finding that there are a lot of violations with water quality for these farms in this pool?
In this pool, it is your neighbor does not like you. And they don't like that you have a pile of manure and they want us to go look at it and it's not running off, but it doesn't meet the setback. And so we have to enforce you to move setback. That's
what happened.
the issue.
Okay,
Yeah.
that's good to know.
Yeah. It's complaint driven mostly, and it's relations.
Okay, but it's not necessarily water quality driven.
Not often, no.
Okay, but it is a little bit.
Because they usually have more land than animals, and
Yeah.
it's because it's at the hobby scale,
Right.
typically, right? So it's somebody who wants a few beef animals or
Yeah,
you know,
right.
a couple alpacas or whatever
Mhm.
is in that space
Okay,
on these old hillside farms.
and then I think this is also to Senator Bray's question, Chair Bray's question. So when you were looking at water quality runoff issues, how does that compare? I don't know if maybe you know this, maybe you don't. I'm not sure, but how does that compare to the water quality standards that A&R might be looking at? You know, are they?
They're tied right together.
They are.
They're tied right together. They do all the sampling throughout the state. They get the data, the assessment. If there's an issue, they have to do, you know, intense work in that space. They work with us. We come together and put the projects in that need to happen.
Mhm.
And they have to report all of that up to EPA.
Yeah.
And so EPA is actually, you know, for the Lake Champlain Basin, they looked at all of our regulations, ran it through a model and said, this will meet the water quality goals. You know, we recently just got a good report card. So like, I think everything that you've asked all these years is all in place and it's all working. And again, if you were seeing degradations in these areas, like let's have that conversation, but we're not seeing that. We're talking about bumping things up into a different classification. So I think the paradigm that's set up right now is good. And again, I'm all for when things are not working to do something, but I have a job to do and I want to focus on that. And I'm another stakeholder worker, so appreciate that.
Okay. Any other questions for Mr. Pinker? Thanks so
Thank you
much.
for the opportunity.
Okay, so is anyone else who was participating in all this have any further suggested edits or consideration for us?
Mr. Chair, can I just like have another context of this whole non-point discussion, because there's not agreement, you know, on sort of the state of the law and what's going on, really briefly.
Yeah, sure.
So the study group was in there because the anti-degradation rule doesn't apply to the REPs or the AMPs for logging, so it's both. So the idea was, since that rule is not even going to look at whether or not there's a degradation from those activities, the question is, should we look at that? And it's not just farming, it's farming and logging. That's because they're both excluded from the anti-degradation rule. So we think it's important that we look at that. That's been our comments on the anti-deg rule all along. And as Senator McDonald has been, you know, discussing throughout this, there's just non-agreement about when something's non-point. There's a point when you make that transition from non-point to point source pollution, and that's the debate that we've had, as you know, for a very long time in the legislature. So it's gray, it's not black and white. But for the purposes of this bill and this study and the rule doesn't cover the REPs and the AMPs. And there are no KBO permits that have been issued from A&R to a farm. And logging does not get, for their pollution, a permit, and they're not regulated except for the AMPs. So that's the question we want to get at, whatever the universe of impacts are.
Okay, thank you. On behalf of A&R, is A&R making any suggestions about changes to section 7? I think we didn't have any edits. I'm just reconfirming.
We're not suggesting any changes.
Great. Just wanted to make sure I hadn't missed anything. All right, so I would say that the big question in front of us is whether or not we have the 6,500 gallon prohibition threshold is. And, Senator McDonald?
That's one of the questions.
Yes. So that's, as far as I know about editing the bill, that's a question. What other, and then we had some point edits really that were for clarity, et cetera. So I'm gonna check with our counsel here and see if we've been following the conversation enough to pick up relatively small sort of editorial.
Yes, I can walk you through what I believe was the markup we agreed to and the markup that remains the question.
Great, so let's do that. That will be helpful for everyone here. One version. Thank you.
Sorry, we're not exactly, these chairs are not meant for.
Now I understand. So I'm just gonna walk up the markup suggestions that you've received. So page 3, line 2. It should say no person shall cause a discharge of waste into a Class A water.
Water,
And
Not plural.
water should be there.
not waters.
No, I think the singular is appropriate there. There's actually a section in law in Title I that says the singular can be interpreted as the plural, and the plural can be interpreted as the singular.
Oh, cool.
Great.
He would know.
So then the next question, which I don't believe you've reached an answer to, is page 3, lines 13 through 16, and whether or not that prohibition on systems with a capacity of 6,500 gallons or more per day in a Class A or B1 should be included.
Okay, so like that one. Let's keep going on the other edits so that we see it. That's 8 questions, right?
Page 3, line 17, sec 3, I believe you've agreed to say that indirect discharges to the waters of the state from on-site disposal of sewage shall comply with and be subject to the provisions of this chapter and shall obtain the required permit.
Period. Right? Got it.
Page 4, lines 5 through 7, the struck language would remain, but there's the word "and" between capacity and shall, at the end of line 6 needs to be struck.
All right, I'm looking at different numbers. I mean, I don't have line numbers, so wait, my print.
So the last sentence in section 3 says existing indirect discharges from on-site sewage disposal less than 6,500 gallons per day capacity. And then it said "and shall," that "and" should be struck.
But we're taking that out.
Yes, you're taking the whole thing out, but that language, that "and" is not supposed to be there.
Oh,
So,
I see.
okay, so, but it's, okay.
Right, so, got it. So, what we're striking will be accurate.
Oh, yeah.
Got it. Thank you.
Page 5, line 10, it should say on the secretary's own motion instead of petition. That same change is made page 5, line 17, on the secretary's own motion instead of petition. Page 6, line 2, I don't believe you changed this. The agency requested to change the date from 2024 to 2025, but in your discussions, you agreed to leave it at 2024. And then the remaining issue is really section 7. I don't think you've had any agreement on markup here.
Right, so then double back then with 2 real questions for into a next draft. The 6,500 gallon provision that's line whatever 13 through 17 or something like that on page 3. And so I'm gonna, usually I talk, I don't necessarily lead on a piece of discussion, but for me, given that we have, so there's some history. Since 2005, we've been aiming to get the anti-degradation rule and waiting for it. And there's 100+ waters that get reclassified. If we move forward, and this has been an obstacle, and the new permitting paradigm, given it's also supported by a cumulative impact analysis, to me, I'm willing to say, okay, it's like a rational science question. Like, did we design a good permitting system? And we'll count on it, but not count on it blindly. So we have that annual report that lets us monitor the impacts of the changes. And I'm sure that all parties that are interested will remain vigilant about what happens. So I think it's from that point of view that I'm suggesting to the committee that we take out that section, revise in order to remove the, well, just say strike that link, whatever the proper revision is, that is prohibition. I don't know if there's any. It's sort of like a Fisher cut bait moment for making such a change. So I don't know if I'll just ask. Take go. We're saying that
The last sentence in section 2, 1259B.
Right, so this is because we took the 1,000 gallon away. This was to add to increase it to 6,500, and what Senator Bray is saying that he would like to strike that, so there's no cap. That's his recommendation.
My focus has not been on gallons for which we have regulations and data, and elsewhere where we don't look at stuff.
Okay. So there was an answer, something you could support or you prefer not to?
Yeah, so I think that is something that I could support. Especially if our permitting process is robust, then I think that is, something I can live with, but I also appreciate that there are these report backs, so that we'll be able to check to see if it's working as we expect.
Yeah.
And especially with the prospect of being able to reclassify waters.
Certainly.
I think I made my case, and I support the change as you've recommended it.
All right, so let's adopt that change, please. And then that brings us, jump all the way to the last discussion area with section 7, the nature report. Having heard the back and forth over what is and is not addressed and how it is not adequately regulated, or who regulates in what way, I think I have not heard in my time in the legislature, it's just a clear articulation of this issue. And my hope is the stakeholder group can bring forward a more clear articulation of where we're at in this space and set up the next legislature to the next legislative session to act if they think there's something to do, or to get the report and say, we don't see any need for further activities, but at least we'll have better information in order to move forward. So it may be comprehensive enough that certain things won't take long to address. And if that's the case, then I won't see the report as released. And with all due respect, every operating area, which I know is busy for sure, and this committee is always going to bat for each operating area to get the resources.
Yes.
So I'm appreciative of the fact that the Agency of Agriculture is busy as is Agency of Natural Resources. That still seems like a question that I'm asking.
Yeah, I fully support that, and I think we should keep this section in. And I didn't catch any changes that we would make to it either.
Mr. Chair,
Yes,
it's
sir.
a chicken and an egg. And I just heard it. My lead thing is there is no actual data. And when I look at the bill and I look at what's going on, in the case of forestry practices, that's for several years, that if you're performing a forest cut, clear cut, this cut, that cut, the next cut, there should be a method to notify the people who come and take a look at what you're doing. Because that's how you collect data. And it has been posed over and over and over again. And if you're going to clear cut 10 acres or 40 acres or do forestry work, if you have to skinny down next to a ledge, next to a brook, and you need to, you're now challenging the accepted forestry practices, that someone from the state is notified that you're going to do this and when you're likely to do it. So they can come around and check and say, attaboy, well done. Or are you guys nuts? You disregarded X, Y, and Z. There's nothing in this bill that requires that data be collected on those sorts of things so we can evaluate policy. The stakeholders have said, no, don't do that. That's I'm going on longer than I intend, that you are disrespecting the professional people that are conducting these practices, and to have to call up and have someone come around and check on us is insulting, et cetera, et cetera. That's just good management, to have someone come around, double check that what's taking place is what you said would take place. And there's nothing in this bill that demands more data to make decisions that protect water quality in the cases rare that they might be when water quality is being assaulted.
Yeah.
There is a provision to address whether notification should be required.
Sub C in that same section, so just above where reports called out, sub C talks about timber harvesting, including whether to mandate implementation of AMPs on all timber harvests and whether to require timber harvesters to notify the state of harvest sites prior to initiation of harvest. So I thought we actually were capturing your concerns in that section.
It gets more complicated because when you're doing a lot of those harvests, you have to have a forest management plan, and that's on record. When you say this year I'm going to go into that piece of forest and do this, that could be anywhere from the end of May until November. And when are you going to actually do it? Is your equipment going in there? Violations are complaint driven today, and the complaint is usually after what the folks are complaining about has already happened.
Sure, but it seems, so I might be missing something. It sounds like though, when we say that we're trying to capture what you're talking about, when we say whether to require timber harvesters to notify the state of timber harvest sites prior to initiation of harvest. So I get your point, maybe they're notifying and they're not cutting for 5 more months, but at least to the whole thing, the state is blind until there's a complaint. This is notification prior to initiation.
Yeah, I would just say I really appreciate that we have section A through C on page 7. I think that really answers what I heard in some of your previous points, especially section B with the subsurface tile drain. So
Well, that's more agriculture than forestry.
but I feel like, so from what I've heard, some of your concerns, I feel like I have seen them be relatively addressed in this part of the bill.
Okay, so Senator Watson?
Thank you. I just want to, I feel like I might be in the minority on this one, but I actually worry about including the tile drain part of the study because it's big. Like, this is a big question, and I don't want this group to get sidetracked into what, and it feels like it is a question worth answering. I wonder if this is the right place to do it, or if it's a separate thing. But that's, again, I mean, I'm just one voice here.
Are
so.
you comfortable with the not having the child rearing conversation in this bill, in this work group?
No, that one is right out of catch-22, the book.
Because it is, your point is.
But it's not gonna make me vote against it.
How do you?
Don't have to go to the mattresses on this one. So, my suggestion is we leave the study as it is complete. And if some of these questions become incendiary, they can be identified as such. A conclusion will be reached, but we might have had more of a public conversation about it. I feel like not having the conversation has become part of the problem in and of itself. So
We are the ones who are tasked with dealing with the incendiary.
yeah,
I'm happy to move a motion for the bill as amended.
Okay.
Is that the right way to frame it? To
Right,
capture
as
it?
with the amendments noted.
okay. And what will the new draft number be?
It'll be draft 3.4.
Four.
So, Mr. Chair, I would move that we adopt as amended for draft 3.4. I think as clerk, I technically have to call the roll too or something. Yeah, what's
Committee bill,
So
so
it's
we're
just a-
amending our draft, and this becomes, we would be reporting favorably the bill as so amended, I think. I don't know exactly, committee bills are a little bit peculiar, but
So
final.
you just
we don't
recommend.
even,
Just recommend,
Okay.
thank you.
that is what I would do, and then I don't need to call the roll on it.
I think we,
You need a vote.
yeah, we do.
Oh, we do need a vote,
It's
okay.
just- It's functionally the same in the end, so we need a piece of
I guess
paper.
we do.
We're voting to amend.
Thought you just said you didn't call it all.
We were wrong, I mean.
no.
We're flexible.
I'm trying to phrase that I like that question provided that deals with, that excludes the, I believe the study and the stakeholders doesn't set clear enough goals. They'll come in and say the same thing they always say. I don't want to, there are lots of parts of the bill where I think it makes sense.
Okay,
When it comes to forestry and agricultural practices, it strikes me as being a free ride again.
so my suggestion procedurally is that we can, yes, we can divide the question. So how would you like to divide the question?
So I'd strike the section that calls for the inadequate study of, it doesn't say.
Be section 7, you would like to vote on sections 1
Yeah, I
through
don't think
6
we have a
and 8.
section that calls for the inadequate study or something, but,
So you'd like to vote on section 6, 1 through 6.
Yes, I'm just.
Okay.
okay, so then the question is divided and we're voting on sections 1 through 6. And do you wish to maintain this divided vote question? I'm just trying to follow what your
I'm gonna,
preference is.
if I may, yeah, I took some notes. Yes, water is being collected and water, and yes, water collected is doing what water does, it flows downhill. Yes, the above is true, but the law does not recognize what is described, where water is being collected and going downhill as a discharge. Even when it flows out of pipes, it's not a discharge in the law and in this proposal. Yes, no one is obliged to inspect, measure, and to regulate, to keep a record of what improvements are taking place. When it comes to the tile drains, you don't even have to record what you've done, so no one knows where it is. Because the discharge, according to statute, does not legally exist and it's not taking place. And that is a kind of blindfolding ourselves. And Mr. Chair, do you have faith that the study is going to recognize this, or is it just going to be the same old? Same old.
I have not heard these questions asked in this way since in public discussion since 2007. So I'm interested in seeing that conversation take place. The outcomes from it, then I think you're absolutely right. It's our job to deal with that. If it turned out that the questions weren't well enough formed to get at something, a committee next year could ask the questions directly by taking testimony.
And Mr. Chair, I would just say, to your point, I think without the study, you're even less likely to get some of this conversation going. Again, I think this
So
is your.
who's going to sit around the table and just discuss?
So
this thing?
we do have the,
That's a whole story.
maybe we should spend a little more time on it, but it looks like we've got the secretary in consultation with Ag, Food and Markets to convene the stakeholder
A
group.
stakeholder group.
So we don't have like a list of what they would be choosing the stakeholders.
And obviously you would be welcome to participate.
Yeah, I think this is the opportunity to hear this.
All right. So with that, let's vote sections 1 through 6.
And can we include sections 1, 6, and 8? Because that's the,
Effective date.
yeah.
Yeah.
And that's just section.
Okay, thank you for that helpful catch.
Okay, so first I'm gonna do section.
So I will withdraw.
Oh.
Request the divide question.
Oh, okay.
All right, so then the question goes back to, thank you, Senator McDonald, to voting the bill as amended in redraft 3.4.
Senator McDonald,
Yes.
Senator McCormick, absent. Senator Watson.
Yes.
Senator White, yes. Senator Bray.
Yes.
Okay, the vote is 4-0-1.
1. Would anyone like to report the bill? Senator McDonald?
Did you want to report this one?
I will pass.
All right, so I'll report the bill. Thank you, everyone. Thank you, Mr. O'Grady.
Your temporary rule 44A passed the rules committee.
Okay.
So,
So I don't know when that will happen.
right, so procedurally, though, because it's a committee bill, don't I take something back? to
Yeah, you have
legislative
to take it back to
operations?
legislative operations. It'll probably be put on notice on the calendar tomorrow, then move to rules.
Right,
And then has to come out of rules. And
yeah,
then it goes back on notice again. So probably not looking for action on this until.
next week. Okay, and meanwhile, I'll talk to Secretary Bloomer about whether it needs to take a detour under 41.
Yeah, I don't think so. I mean, it's just how John reads a bill sometimes.
Okay,
But if you could probably convince him
all right. So, thank you, everyone.
Thank you.
I really appreciate the fact that there was a lot of material, there's technical, there was a lot of thoughts back and forth, and I appreciate that people really worked in a timely way to bring forward a draft. Now we can move something, and there's a fair amount of process ahead of us still, but it's been a long time coming.